appreciate being here, and let's see if the only challenge I'm having today is the buttons on the slides are a bit grayed out in my version. Are you able to move the deck forward if I call for it? Okay, I may rely on you then for that, Professor. So first of all, thank you for the chance to recap and for participating. Let me tell you where we were coming from in proposing this. We're a little bit of an unusual structure in terms of a think tank in that we have, we're industry supported, and our board ends up being split. We're half chief privacy officers, so it's the folks at companies that are worrying about how to make sure they follow the laws, they follow the rules, they do it right. And then the other half of our advisory board, in terms of setting our agenda, are advocates and academics who very often are concerned about the downside of data use and the risks and the potential harms. And so it ends up putting us dead center. And when it comes to the de-identification debate, I think it's an interesting place to be because one of the issues that I think folks who are in this in a very practical level and who are thinking about how hard I need to work to de-identify or what's the standard that I need to follow, I think need to look at it as much broader than a legal problem, much broader than a technology and handling data problem. There's a much bigger set of privacy and data debates that are going on, and depending on where you come from in those debates, you're going to have a different filter to how good you think a certain de-identification is, or how much work you want a company or a government agency to go through based on your perception of the value of the data. I think that's not always a useful frame. So what we wanted to do is put the debate a bit in context and step a little bit back and listen and hear from some of the smart people on every side of the equation. So let's jump right in. I will tell you one of the things that we did, which was a little bit concerning to some. Many of the folks who are closest to the very practical de-identification issue, of course, are folks working with health data where they're following legal requirements already. And certainly that's where there's a very important part of this debate and conversation. And so when we showed up and we said, well, okay, but we want to talk about how people doing targeted advertising who claim data is de-identified or anonymous, what they're doing as they pull in different kinds of data. We want to talk about what people doing traffic management and location GPS, Wi-Fi router database assisting type services. And so some of them say, whoa, wait a second, we're curing cancer here, and so, everyone agrees that our data really needs to be, available, and of course that it's got sensitivity and we need to, follow the rules. Don't mix that in. And at the same time, we were quite aware that some of the critiques of de-identification measures come from folks who are critical of the various, sometimes very low steps that others are taking, and it ends up casting, I think, doubt and criticism on the entire field. So we made the decision to look broad, and I think it makes sense. There's obviously data that is already legally protected and may have particular legal standards for de-identification, but then there's other data that the consumer may not appreciate or understand is not technically covered, right? We've got personal health records where the data may not be data that's covered by the particular relevant statutes in each country, but the user may just know that it's his health information or what he considers sensitive or information that he wants to see, highly protected if he's been told. So we thought it makes sense to blur to blur this and to see what lessons we might learn from the different options that are there. Okay, Khaled, would you hit the slide, please?
You should be able to do it yourself. I'm just.
You know what? It's for some reason it's not happening.
Okay. All right.
Great. So, one more, please. Okay, so our opening speaker, one of our senior fellows here, Professor Peter Swire, who played an active role when the Clinton administration was working on HIPAA as the counselor to the president for privacy, helped frame what the concerns that the critics or those who are worried about access to personal information are worrying about. One of the areas that he's written about is the concern about peeping, and he's written an interesting paper around that, and his sort of argument is one of the reasons that folks can get some assurance when data is protected, de-identified, is that employees who have access to the consumer records at companies are, as we know, occasionally tempted to access accounts that they've got no business accessing for purposes other than their particular job skills. We see this obviously when it comes to State Department employees peeking at White House candidates passports. We've seen it when it comes to employees at social networks or companies that have account info and who have no reason to have access to a celebrity's profile. During my years at AOL, we occasionally had this. At one point, lots of people had AOL accounts, as some of you may recall, and there were various celebrities, and one of the concerns was would employees be improperly accessing, and so Peter's argument has been that one of the things you assure by having data both sort of locked down so that there's not inappropriate access, but also perhaps not easily identifiable, is sort of the peeping problem. He posits, of course, that we seem to be concerned about the outside hacker problem, that somehow that's going to be available to bad guys who somehow get in and want to de-identify the database because the information is interesting to them. I think obviously there's some skepticism about whether that is a substantial problem, but obviously it's potential. And then his sort of third framing was that we're worried about data that's made public, and by adding other information to it, it can be de-identified. So the Netflix situation, again, at AOL during my day, we had an unfortunate incident where one of our researchers wanted the academic community to have wide access to our search log files and posted them in a way that was only trivially, in his mind, but substantially enough, he thought, de-identified. And, again, a very small number of individuals were identified by reporters who did some sleuthing, but these have been obviously cited as wide examples, and how widespread it is obviously one of the areas of debate. I guess Professor Sweeney it kind of fits right in as one of our opening speakers following Peter, who set the day up, in that obviously she spent a career demonstrating what, with enough time, computing power, research, and savvy, can be done. And although at the end of the day, of course, her conclusions aren't that the data ought not to be collected or shared or used, but that there are substantially better steps that she believes need to be put in place to prevent any of the potential identification. Professor Imam, I think you pointed out, among other interesting things during the opening panel, was that these attacks, either as Latanya has presented or the popular examples that I have cited, what do we learn from these? Are these actual risks out there, or are these sort of demonstrations of what's possible, which we should understand, but also consider whether or not these are actual risks? And indeed, the study showing that half of these attacks really are demonstration that we don't have this giant audience of hackers that are seeking to access de-identified data because of the practical limits on how useful some of this is to them. So useful to understand, but in terms of assessing what our policy response should be, whether we should react and perhaps create significant challenges to the data is a different story. Oh, I am having connection problems, and so my deck has gone. I'm going to pull up the hard copy of it. Sorry, while we speak, and hopefully you'll be able to follow it along for the audience. Sorry, the challenges of technology. Okay, I'm looking at my hard copy now. Professor Kisti did a study that many listeners may be familiar with, where he highlighted the reality that today, if your face is online somewhere, experts, researchers at least, and perhaps government agencies, or maybe soon people using some of the consumer available, there are obviously Facebook apps that help let you do facial recognition. I'm not talking about the technology that Facebook has built in that ends up relying on a set of controls that Facebook's built around it. The Facebook controls don't let you upload a picture and have it identified. If you know this user because they're a friend of yours and you've got pictures of them already loaded, it uses data that you have in your immediate network to suggest a tag and provide some tools for users to say, well, no, I don't want to be part of that. So it's sort of an example of the consumer tools starting to pop up, but popping up in an environment where you can actually build some rules around it. But clearly that same sort of technology could feed a broader database, and there already are tools out there. And so his argument, although again, at the end of the day, his argument isn't let's not make this data available, but let's be highly aware that your face in public, to the extent that you once had some sense of obscurity by being in some crowd or due to the unlikelihood that you are being pervasively recorded, I think his argument is that those days are long gone, and a face in public in the right hands and right technology can be identified. So we wanted to sort of launch the program by setting out some of the concerns by the folks who've been very publicly associated with criticisms of de-identification or expectations that users might have of not being identified because of obscurity of some sort. And having said that, we thought we ought to shift a little bit and start thinking a bit further. If somebody comes to the table with a fairly low appreciation for the way data is being used, it's very easy to see only the risks and call for quite a high barrier. By assessing, what are the benefits of this data use, by assessing what the actual pragmatic risks of identification are, we can perhaps think about this in a little bit more balanced a way and sort of assess how hard and how high we want to jump for what kinds of data and what sort of circumstances. So our next panel, Harlan Yu, is an interesting young PhD student and researcher, has done a good deal of work on how government agencies who are responding to the call for open data, putting court records online, putting all sorts of government data collected, at great expense, and locked up and generally in the past inaccessible beyond the agency, or frankly not even accessible to do anything other than what it's been designed for at the agency. So the movement to put that data out so that third parties can build great apps and mashups and add some real value to that by providing that data. Quite a compelling movement. Countries around the world, quite a push behind it. Certainly in the U.S., it was at least initially a very big priority and still on the agenda for the Obama administration. And immediately there were concerns about the privacy issues of that, and he spent some time showing us some of the work being done around making those public records available for all kinds of intriguing, valuable, helpful purposes, and taking steps to screen out and eliminate and worry about potential identifiers. I won't talk a great deal about the Sentinel project. Folks can take a further look if interesting. But the goal there, I think, was to show the work that the FDA is doing to be able to use its data sets in a way that is protective of the public. Professor Daniel Barth Jones, I thought, brought an interesting perspective in some of his comments where a concern that he flagged was that some of the methods that have been proposed to de-identify data that would certainly add, in some degree, significantly to the protection, but by adding some degree of obscurity or obfuscation or randomness, which is what some of these rely on, you can actually end up, if what you need is really accurate statistics for the inferences that are being teased out, given the size of the particular audience pools that are being tested, you can actually have some significant issues and make bad decisions because of the challenges. Now, there are opinions on each side of that debate, but I think it's a valid concern that we need to think about. One of the typical answers from data regulators, of course, when we talk about large data sets that are going to be used is, well, just ask people to consent, and since it's a good cause, maybe they will. And obviously we've got some obvious challenges in that most people just don't have the time or interest, or it can be a challenge to engage that, or at least this may be a data pool that was built up by default because of a different process. Or the answer is, well, at least let them opt out. And although the opt-out rates in many of these areas end up being quite low, again, if you need highly accurate data, one of the areas to certainly keep in concern is some of the effects. And I think one of the challenges is that I'm not quite sure policymakers understand that. The view is often, look, this is kind of marketing data, or if people don't consent to this, well, then maybe you shouldn't be doing it. And one of our goals is to sort of bring some examples to things that are actually useful for society, for people, but because there's maybe not an initial payoff, I push the button and something tickles me and or gives me a reward, I may say no in a substantial way, even though there's minimal privacy impact and significant value. A good example of that, just to mention, would be we've all sat at our computer when our browser has crashed. And both Internet Explorer and Mozilla Firefox have told me that little pop-up that says, would you let us have this crash data? It's not identifiable, and we're going to use it simply to try to figure out, why browsers crash and make improvements. Kind of nice. We don't like it when they crash. They get an enormously low opt-in rate, tiny. And it's not because people are worried about the privacy issues usually. In kind of my polling of folks, it's been, I don't know, maybe to delay me or something, or I just want to make it go away, so I say no. And as a result, the browsers are not getting the data they need to improve or make very smart decisions. Another example of that is in Europe, where there's currently a lot of debate around the use of cookies. The e-privacy directive, or the cookie directive, as some folks call it, which passed 2 years ago, has led a number of European Union countries to create an opt-in for cookies, others an opt-out, and there's substantial debate over whether it's opt-in or opt-out, but clearly we're seeing a number of countries taking this as an opt-in, and therefore great concern with just about anybody who sets cookies. The Information Commissioner of the UK, who's been involved in this debate, is generally practical when it comes to data use, but on this has said, well, let me show you that people will choose to have their data used or not, and he put an opt-in for the analytics, and again, not tracking people for some marketing purpose, and not giving it to some company, giving it to, well, I hope a trustworthy data custodian, the privacy commissioner of the UK, a cookie which simply would track how users pass through the site in order to make better decisions about, can people find what the site intends for them to, have available, and how is it working, and so forth. Since he's also the Access to Info Commissioner, when folks made Freedom of Information Act requests to say, can we have your log files for your analytics before and after your opt-in? And sure enough, before it was very high. There were, some people maybe opted out of cookies or the like, but they had 80-90% of the users contributing to the analytics program. And after the consent process was put in place, the number of users plummeted. It was just a tiny fraction. And so the challenge of consent as being a solution, obviously there are places where it's necessary and a must, and it's marketing related, or it could be intrusive, but it always being a solution is a challenge. The next slide, data use for consumer services. The goal here was to try to give some additional examples for policymakers to understand around how large data sets do something useful. It's easy, I think, to say we understand that health researchers are looking for great cures and studying the spread of disease and so forth. But the examples that are at the fingertips of folks in the policy world when it comes to other data end up being very narrow. People say, well, Google flu trends, that's useful. It's great that Google's been able to work with the National Institute of Health design, tool that can alert to the spread of flu before the emergency rooms are full. But after that, people end up being, something to do with traffic. And so we thought we should start highlighting, and we intend to do a bit more of this over the upcoming year, different products. And again, some of this is probably painfully obvious to some of you. It's remarkable how it's not to policymakers, even fairly sophisticated ones. I was, as some of you, in Mexico City for the annual meeting of the privacy commissioners from around the world, and there was a session focused on big data, and the keynote speaker, a reporter from The Economist, gave a really interesting overview of all sorts of efforts, big and small, by companies of every size, that are using large data sets in really interesting ways to tease out new products, new patterns, new information. The panel of data commissioners that followed, including the chair of the Article 29 Working Party, the advisory committee of data regulators who sit as a group to opine on their view of how European data protection law is to be applied throughout Europe, as well as another number of his colleagues. The reaction to the presentation was, big data needs big enforcement. The solution here clearly is that if there are companies doing this around the world, large multinationals of the like, we need to work to better team up to rein that in. It wasn't this is really useful stuff. We can see the downsides of this data being exposed or being misused in ways that are harmful or risky or just disconcerting, and how do we make sure we have the good and not the bad? It was very much, I just have been told that there is a commercial byproduct called pollution, and we need to minimize it as much as possible. And so I think helping folks understand that there are both benefits and risks, and our goal is to optimize the benefit and minimize the risk, as opposed to, just ask folks, because that always is the answer and solves your legal consent problem. It doesn't always work, or just minimize and don't collect. Again, important roles for all of those in the equation, but not always the answer. And obviously, the de-identification piece being a key part of the solution. So our Google participant was one of their senior engineers who has built the Google Translate product, which frankly I always figured they employed teams of linguists who relied on technology, but clearly translating languages means having to understand great detail about the makeup of languages and the like, and it was indeed eye-opening to learn that the way this product, which is pretty good, although for all of us who've used it, imperfect, but often quite useful, that this product now allows 63 languages, I think, to be translated into all of the other 63. I could be wrong, but 63 languages, as he's described, built purely on scrolling the web and looking at public data. And this just indeed sort of a remarkable example of using a giant data set in a incredibly useful way. Our friend Jules Cohen, one of the privacy folks at Microsoft, talked about the location services database. Now, this is something that most people were not aware of probably until Google launched this into public attention when it was found that their Google mapping vehicles that drive throughout the world, videoing, everything and anything, so that they could enhance their mapping services, that it was also logging the MAC addresses, the IDs of the Wi-Fi routers that it detected from houses and businesses, and it was inadvertently, if your router wasn't secured, logging the traffic in communications that were going across it unless they were otherwise protected. So this became a giant scandal, even though Google was accidentally deleting it and so forth. But what was interesting for folks was, why are they logging everybody's Wi-Fi router? Of course, they and Microsoft and Skyhook and a number of other companies, including just about every one of you who uses a cell phone, you're contributing as well the location of the router that you're on to Google or to Apple every time you turn on the phone or when you use a location service. So these databases have been built so that when we turn on our phones, instead of simply relying on cell tower triangulation, the local Wi-Fi routers that your phone can identify can be looked up, and since they've been logged as to their precise latitude and longitude, your phone much more quickly, with less strain on battery, knows where it is because it can rely on this crowdsourced database built off these cars that are driving around and logging these. Microsoft explained how they work to limit and de-identify the data so that there's no specific reference to a user. So, for instance, many of you name your home network, Jules' home, so that you can get on it. They'll avoid logging that SSID or network name information and limit it to the MAC address. But again, an example of a tool that nobody would opt into. Now, Google at the end of the day, when it was done dealing with the regulators who were worried about the accidentally logged information and the process for destroying that, the question is it legitimate to do this? Is this personal information that is being, it's attached to people's home devices? Is this personal information? Nobody's opted in to do so. There seems to be no way to, quote unquote, opt out, other than maybe putting up a metal wall in front of your house so that you're or somehow hiding your network. Obviously, the most obvious example. It was curious to see that many of the regulators didn't respond with, "Oh my goodness, why does everybody have their home network open? Forget about Google. They made a mistake, but they're probably not a bunch of crooks. What about all the crooks who are driving by and able to access your name and your password and your banking and whatever else that you're doing on your open network? Why aren't people hiding if they really want to be highly sensitive, or b at least setting a password so that their network isn't accessible?" The response, was more, "Don't drive by Google." But in any case, what they did result is they did accept an opt-out process that Google put in place because of at least an appreciation that despite the fact that they were going to consider this personal, and folks in different jurisdictions might debate whether that data point is personal or not, but they decided that even though it was, and even though users weren't opting in, an opt-out process, and frankly a very difficult to use opt-out process, not everyone would know how to go in and rename their network. In case any of you want to go ahead and become invisible to this service, well, I'd say don't, because you probably use it every time you turn on your phone and your GPS, uses it. But if you do want to be a free rider and use it, but not be a contributor, name your home network Jules Home No Map, and so there's a format that can be done. But I think you saw the policymakers, despite I think in other areas being critical of such, being willing to accept this because of the value of the data. Another decision that may end up being interesting or useful to us, folks probably saw the Supreme Court argument or coverage of it in the U.S. v. Jones case, where law enforcement attached a tracker to someone's vehicle, and the court now needs to decide whether that is the same as simply tailing somebody where you wouldn't need a warrant or the like because they're out in public, or whether there's something that means that the pervasiveness of the tracking, even though it's outside your home, even though it's not on your body, on areas that might be in the U.S. protected by the Constitution, you are in public. Clearly, we think the cops could, secretly drive and tell you if they thought something was going on. Is there something about the ubiquitousness of the nature that somehow means that this is a kind of data that needs to be more highly protected? So it will perhaps have some greater insight. We then had a panel focused on the advertising and marketing uses and concerns. And, here's where I think we've seen concerns that are now leading to this general view, well, just don't collect it at all, in a way that I think challenges many of the other data sets that are being used for highly useful and valuable purposes. Some of the sloppier practices that have existed in the online ad ecosystem, or the perceived intrusiveness of it, has become the prism that underlies privacy thought for major databases used for, highly societally valuable uses. And so I think it's important to just understand that the researchers of the world that are there to solve the most noble problems are living in a world where data generally is being viewed through a prism that is very much defined by Facebook, that is defined by behavioral advertising. These are the issues that the policymakers, see the most and want to respond to. And it's not always easy to draw a bright line between the areas once one starts proposing technology or data solutions. One of the interesting technologies that surfaced this year is one that Canadian company Bearing Media, who has done some interesting work around privacy by design and using ISP data to location target ads. So controversy was kicked off a couple of years ago when ISPs began considering working with companies that would examine the surfing of users and then make that available to ad networks for ad targeting. And the backlash against that led to litigation, led to most of the few companies who had rushed forward dropping those sorts of plans. What Bearing came back and brought to the table is a plan that doesn't rely on your surfing, but rather recognizes that an ISP, because it knows the users, it authenticates its users, it uniquely may have the actual geographic location of the user that they're registered from, or their home, or they're coming in from their ISP connection. And rather than share that with advertisers, Barings helps set up a process where it can solicit ads from advertisers, and then on its side, with appropriate large enough cohorts, target the ad to the geography that the advertiser requested, and they've got an interesting white paper. They launched that with Verizon this year. Verizon notified all its users with an email and with a mailing and with an opt-out process. Created some initial attention and concern. Policymakers wanted to understand how it worked, but seems to have now been proceeding acceptably. So we thought their de-identification method in the marketing world was something that we should highlight. Quantcast, using a more typical targeted advertising structure, again, something to be aware of because this is what's driving a lot of the debate, explained how and what they do, given the kind of data that they're using, cookies and web activity invoked to help tailor user ads. And again, there's obviously been debate around what more should companies in that space be doing. There's been criticism that websites are accidentally, sometimes maybe intentionally, leaking the personal information they know about the users to these third parties who are acting across a range of sites, and the concern being that those third parties would have in their log files or somehow know personally what you're doing on many websites. If that data is leaked, certainly an area that has gotten a lot of attention, criticism, and where industry folks could do more to beware of that hygiene. This has been an issue for probably a decade. In my early years at DoubleClick, this was constantly a problem, and we had to put in place processes not only to teach people how to use the tags right, so not to send us what we didn't want, but processes to make sure that we didn't get what people were accidentally sending. And the fact that we didn't know it was coming, or that we didn't want it, or we didn't use it, didn't matter. We were going to be held responsible for the fact that a critic could see this data going in our direction, and so it's just something that companies should deal with. Peter McGee at the FTC talked about the Commission's view, and this is something that I think has been evolving. A decade ago, the Commission, I think, saw a very bright line between personal and not. When I was at DoubleClick and we worked out with the other ad networks and with the FTC what the rules should be, for instance, for behavioral advertising, if a user's name or address or very specifically identified information was going to be linked, there was one set of rules. If you were limiting your collection to cookies or log files or IP addresses, that was considered to be not identified, and there was a more lenient set of rules. 10 years later, when the Commission came back and said, well, look at that AOL search data and look at the Netflix situation, and we know that while an ISP has data behind that IP address, and because of the deep packet inspection model, we know that they could bring their knowledge to bear to help tailor ads, so we therefore are going to move more to a view of could this data be linked to a user? Is it possible? And the first example I think we're seeing is right now the Children's Online Privacy Protection Act is getting its update, or at least the regulations that the FTC controls that implement that are being updated. And in it, the Commission, again, concerned about behavioral advertising to kids in this instance, is using its ability to define what is personal when it comes to kids' data. So this is only kids' data, but when you see the analysis, you can see how it potentially applies to broader thinking. They said, since we want to deter, at least without parental consent, behavioral advertising to kids, and since we can regulate whether or not data is personal when it comes to a child, they said that if you track a user with an IP address or with a cookie across more than one site, that is by definition personal, without regard to how it is used or what you do to try to identify or not. Simply logging across. So if I'm a third-party vendor, if I'm an analytics company, if I provide any sort of infrastructure to a kid site and another site,
the data is deemed to be personal. Now, they've taken comment on that, and one hopes they'll narrow that somewhat to focus more on the behavioral piece and not simply logging, because I think it starts to really blur what is identifiable and what's not. In a way that doesn't support any sense of logic, because it's the only method they have for reining in behavioral. So I appreciate their motivation, but they start bridging, I think, some logic around, does the company promise not to do it? Does it work to highly de-identify it? Are there technology steps in place? It's the tracking across, and I think hopefully they'll narrow that, but this is something they can do now. They don't need legislation. This is a regulation that they have the ability to update. Justin Brookman from CDT added some useful points around the distinction between first parties and third parties, and I won't go into too much detail. I do want to make sure we have time for questions and want to jump to our academic panel. I urge folks who haven't read Dan Solov's law review article on the PII problem, privacy, and a PII 2.0 concept to do so. It's available online if you would like a very brief review of it, because you're really busy. We put out a journal every year that chooses the top privacy papers that are most relevant for policymakers, and our advisory board votes on the ones that are most practical. Dan's was one of those, and we have the authors write us a very short college paper with Dan Kavukian as well, was one of the winners. Amongst lots and lots of interesting papers that were presented. And so each of them has a brief summary of their paper that we have published in our little journal, which is available online at our site as well. Dan's main critique is that living with this black and white world of things either being personal or not, personal, and then all the rules cover not personal, and then they don't, forces us into these very awkward challenges where we see sorts of data that seem to call for more protection or some sort of limits on use, and we don't have the model other than, as the FTC did in the kids' privacy example, of saying, okay, well, since it's personal, now this applies. You see this perhaps most extremely in Europe, where generally the rules have applied, at least by law, whether the data is personal or not. And so for quite a long time, many European companies said, well, my data is not personal, so I don't do anything. U.S. companies, for many years, were a bit more flexible. Whether it was personal or not, well, they'd give you the opt-out of the cookie. They'd give you some choices around it without debating necessarily, or frankly, usually by just calling it anonymous, but yet being willing to provide additional user controls. So I think there's been although not a policy evolution, you've seen companies doing so. A perfect example is in jurisdictions where providing access to information is usually tied to whether or not the information is PII, and then you're obligated to do so. For years, there was a call for the ad companies to let you see your clickstream profile, and many said, well, it's not personal, or I can't do it. And now Yahoo, Google, Microsoft, many others do provide, if you surf through their privacy policy, a way for you to see their ad preference managers and see, even though they would argue that you're not identified, but they'll read back your cookie and tell you the different categories that you've been put in. And so Dan's argument is that we do need a little bit more of a spectrum approach, and although we need to know what non-PII is and we don't need to know what PII is, we need to recognize that perhaps depending on the gradient of how the data might be used or the particular nature, one might have a number of in-between stages. I'll conclude by just referencing some work by Jane Yakowitz, which folks may be aware of. Jane, as many know, is a critique of some of the louder concerns that there is a giant de-identification problem, talks about the value of having much of this data available in a commons and that it's accessible, and that some of the de-identification attacks are have gotten much more attention than the actual threat and risk to the data was. So That was our event. If you have 8 hours free, the full video of it, or at least you can choose the various panels that were interesting or not, is available if you look for the December 5th conference info at our site. Love to take questions. Khalid, I am still in a connectivity challenge, so if you can pick or choose, I'll respond and welcome your thoughts. You were there and engaged, and appreciate your participation. But any other thoughts from the event or that you think the audience ought to hear?
Okay, great. Well, thank you very much, Jules. I really appreciate this. So I've put the text box on now, and we'll just give the participants some time to type in their questions. While we're waiting, I did have a question about the FTC, and I was wondering about your thoughts of whether you think that they will, there's any chance or any possibility that they would shift their perspectives on the distinction between identifiable and de-identified data. That blur.
Yeah, well, you know what? Let me just say a word about sort of the major two things that are coming from the FTC, sort of aside from the kids piece. I think the Department of Commerce here obviously is going to issue a report. It actually is going to come out from the White House, and we'll have the administration here for the first time an administration has ever formally taken a position on a privacy law generally. As I've been filled in, and as folks saw from the early version of this, the so-called green paper, the plan is to have a fairly high-level proposal that industry groups will fill in. In their high-level proposal, which won't be bill language, but will set their view of what a national, federal U.S. privacy law would look like, as you imagine, is some definitions of personal information. It is, I believe, general enough that depending on your view here, it'll be too narrow or too wide, and their view is that the multi-stakeholder groups that are going to be convened in various industry sectors, and what those groups will be, what topics is yet to be determined, but that different sectors might define what personal information is in that sector. And the FTC's kids privacy step was pointed to as sort of an example of how, depending on what the sector, PII could be defined differently. Now, I need to think about that kind of concept because on one hand there are some pieces attractive about that, in that it does help some of the arguments that I think we highlighted, that if there's really high value to data and if there's perhaps a minimal risk, then perhaps the definition of what is personal in a particular segment might be different. Let's say there's PII and then there's legally PII. Maybe that's a way to think about it. We're not going to dispute that researchers and technology can achieve some identification, but whether something legally is PII of the nature that needs to follow some particular set of rules. So I think that'll be quite telling. And then I do think we will expect to see the FTC talk a little bit more about what they view as identifiable in their privacy framework. Whether or not the kids' privacy thing is a foreshadowing of where the whole report, that was my exact question when we held a briefing with the drafters of the kids' privacy regulation. We said, is this you, the kids folks, thinking about, how to make sure behavioral is not there for kids, and this is the tool you have, so that's what you're using, or is this the logic that aggregating across because there's a cookie, because there's an IP, amounts to PII, and I haven't gotten a good answer to that, and I think the report, which will probably follow the administration report, will go further in that direction.
Okay. Thank you. So we have a question here. Did the speakers at the conference address PHI, personal health information, and the de-identification of PHI for research purposes?
I guess we didn't go very deep into the specific criticism of or nature of the steps that need to be taken for specific types of data. So no, other than to recognize the range of the kinds of data that could be collected, and to argue that, at least some argue that, depending on whether it's data that could really be harmful or that users would have a high interest in ensuring a high level of protection, that various levels. I think the most useful thing that came out of some of this conversation is that in the areas where there isn't legal guidance, lots of companies are operating in a bit of a vacuum. There are lots of people who say, what I do is anonymous, or what I do is de-identified. And then they turn to each other and say, what does that mean now? How big does the bucket need to be? Or I'm encrypting, does that work? Or I've got a process where, I've appended, but I'm not holding the identifier. I mean, there's a whole range of some good, some careless, some, highly good processes, and there's very little visibility. And what people urged us to do is not so much create best practices, because they take a long time and they take a lot of compromise and so forth to get everybody on the same page. But even creating some visibility, some privacy pattern guidelines, so folks could see, well, responsible company generic, A, did this sort of thing when it was marketing data, or here's what was done when it was this sort of health record data. And that's something we're considering doing. I think it'd be useful, and certainly part of, I think, the value that the Electronic Health Info Lab adds to some of this as well.
Thank you. What about the presentation by Acquisti on facial recognition? How much of a problem do you think that would be in practice?
I'm not sure there are too many of us who think that when our face is there in a mob anymore that we are invisible. I think we've kind of, for better or worse, realized that between video and devices and all the potential logging that happens when I'm outside my house, there is a lot of potential identification. I think that so the discovery that if your face is on the web, to the extent people used to think they could post a porn video and nobody would know because there just wasn't any method, or there'd be a shot of them in a crowd. I think we've lost some of that because the technology can log. I think we need to focus on how do we make sure that the uses that are there are minimized, are controlled, that users have some ability to do something about it and take greater steps. But it's hard to break and say facial recognition should go away. The reality that your face can be represented in a digital way, and that therefore the technology creates capability, isn't going to be fixable. I don't think we can say to Facebook, magically don't, give people the pieces of this technology that they want. I do think we can try to take the example that perhaps Facebook did, which is when I'm using this, I want to do it in an environment where I'm able to build parameters around it. I can only identify my friends. So if I'm a consumer company, or if I'm providing digital billboards, CDT has done some good work around if I'm providing a digital billboard or an in-store technology that's counting users, or counting users and reporting on the sex of users, that structures can be built around that. Commissioner Kavukian has a wonderful paper with the lottery in Ontario where folks who wanted to be on a list of people who were problem gamblers and wanted to be stopped when they came into casinos, but one would have to rely obviously on scanning everyone's face, and did some interesting privacy by design work. So although everyone was being scanned, the information of everybody wasn't being maintained when the goal was just to identify the people who wanted to be kept out. So Jeff Jonas has done some marvelous work as well. So there are, I think, technological solutions here that can make sure that companies that use the facial recognition do so in a way that primarily supports the positive and minimizes the negative. The FTC held a one-day session on this, and they're now taking comment as well. And so we may see some information or guidance from them as well for those who are interested in that issue.
Okay. So I think we have time for one more question, and it has to do with enforcement. Do you think that stronger enforcement would help improve current practices by the regulators or attorneys general, or depending on the jurisdiction?
Well, I think two different things have to happen. One, from a high-level policy, we need to figure out how to not jump at every alarm and not be kind of technophobic that because there's technology, it's scary and needs to be dealt with. We need to understand what are the useful things that are being done, what are the actual problem issues, and what are the policies or technologies that should make sure we get the good and minimize the bad. That being said, there are bad actors doing bad things, and most of the folks on the enforcement side today don't have teams of people who are steeped enough in the technology to assess or deal with this well. The FTC now has some limited number of technologists. Other data regulators are starting to, hire some. But as understanding whether something is wrong or not depends on actually understanding the technology. You can't do this without some understanding. Very often what we see is critics look at what appears to be happening at a site, at a service, and ring an alarm. The media aren't well situated to say anything other than someone accused this of that. And we then have this very long limbo process where policymakers or enforcement folks have to learn and study and do. So we do need a reserve of technologists who can help guide the enforcement folks. Yeah, there's a cookie being set. Yeah, there's such and such. But here's what it could do. Here's what they were actually doing. And today that capacity is quite limited, and to the extent that they can have the tools and the people and the technology enforcement, they'll make smarter enforcement decisions.
Okay. And then I just have here one comment. Someone has posted on the face recognition issue. If you use iPhoto to upload pictures to Facebook and people are tagged in your photo, the information will be sent back to iPhoto. So the pictures in iPhoto will then be tagged according to the Facebook tagging. So I guess there's an exchange between Facebook and iPhoto on the Apple's iPhoto product. So it goes back and forth, and it's not just Facebook. I'm assuming the comment is not just Facebook. Other products as well would be getting that information back from Facebook.
Interesting. We'll take a look at that, and I'll comment on it on our site to take a look at that. I mean, I think one of the other side issues that should be mentioned about folks that are posting stuff that isn't always well known. Phones are today the camera of choice, and turning on location is now a default, both in the iPhone and Android. You're pushed to have location on all the time, and as a result, it is quite likely that your camera is geotagging your photos and obviously posting those. Now, Flickr and Facebook and some others do some work to strip out that metadata, but not everyone does, and how well any of them do it, I don't know. They all claim they do. But as a result, certainly people are being surprised to learn that the photos they post online are giving away some very precise longitude and latitude. You can, at least on the iPhone, disable your camera from having that location. We'll take a look at, I'm not sure if Android, I think, is more all or nothing. You've got to turn on location, in which case any app has it. Whether or not the camera specifically has a way to not have location or always, that's actually an interesting question. I'll take a look at. iPhone, you can flip it on and off just for the camera if you wish.
Okay. Well, excellent. Well, thank you so much, Jules. I really appreciate your time today. And for the folks on the line, as I mentioned, we'll be posting the recording of this webinar in the next day or so, and you'll receive an email when it's posted online. And as well as the presentation slides. And Jules' his email address is on the slide, the final slide there. So I think it'll be if you have additional questions, then you can contact him directly and follow up with him there that way. Thank you, Jules. Did you have any last things you wanted to say before we close up?
We post a lot of privacy info of the day or stuff we're doing at our Facebook page at Future Privacy
Facebook.com/Future of Privacy. So give us a like there or follow on Twitter, and delighted to follow up with any questions that folks have. Thanks for the chance to be with you. Khaled, thank you for the technical support as the slides seem to be a bit of a challenge, and much appreciated for your participation in our event and a lot of the incredible work that you and the lab are doing in this area.
Great. Well, thank you, Jules. And with that, I'll close it up, and thank you to all the attendees, and hope to see you again at another one of our webinars. The next one we're having will be at the end of this month, and we'll be sending out emails announcing that in the next day or so as well. All right. Thank you, everybody, and goodbye.
Thanks all.